That's the key word which I wanted to emphasize, the spirit of arbitration. So, I do not know why this book came into my hand. I really do not know why this paragraph drew my attention. And it is even more curious when he says that the problem with arbitration is aided and abetted by the legal fraternity. So, with this background, I would want to address certain things which came in my mind. Since Mr. Vidyashankar has already addressed it sufficiently, and many of you here know the fundamentals of how the arbitration works. To start with, the civil litigation in this country has hit a roadblock, and resolution of civil disputes, particularly the commercial disputes, through the mainstream litigation is time consuming, and I'm sure that it is no longer the preferred mode of dispute resolution. Arbitration started as an alternative dispute mechanism, but now as time has progressed, I find it to be the only dispute resolution mechanism insofar as commercial disputes are concerned, and I don't find any other alternative. Of course, mediation. So I'll address something about that also. Business investments, whether it is domestic or international, it becomes more effective and viable only if a dispute resolution system is capable of resolving it within a reasonable time. Delay in resolving disputes within a reasonable time has plagued this system, and it creates a hesitation in the major players investing in India, fearing the existing system. So, an effective and efficient arbitration system is critical for the effective conduct of business, both domestic and international. What is this arbitration about? Sometimes it's always good to go back and scratch the fundamentals just to have a better understanding. Arbitration is a process where two parties agree to appoint a private judge. That's all about arbitration. Two parties agree to appoint a private judge to resolve their disputes. In view of the same, this is another fundamental which we must keep in mind. The main objective behind arbitration is minimal court intervention in resolution of these disputes. So now that the parties have agreed to have a private judge, it's better that the court does not keep on poking its nose into it. So minimum court intervention comes with it a cost also. As the more the delay, the more the courts, the more the lawyers get in, they become wealthier and the litigant becomes poor. So cost effectiveness is also very, very important insofar as arbitration is concerned. So these fundamentals we have to keep in mind, because sometimes we lose fundamentals trying to understand big things. This is the fundamental of arbitration, right? So, as has already been stated, one of the major advantages is confidentiality, which is ensured because it happens in a private sector. Other thing is that arbitration is also very effective where it involves technical issues like the engineering contracts, the infrastructure contracts, or the manufacturing related disputes, which according to me requires a specialized understanding of the nuances that are involved in that, and for which arbitration is a better equipped mechanism, since you will have domain experts sitting and dealing with the same, which you will not get in conventional courts. At the best, the judges are good in understanding law. These technical things they escape and then become lawyers. And to again make them get into technical issues is like reminding them of their past. So arbitration as such has this big advantage. Right? So how does this work? Again, let us get to fundamental. How is it working? How does it work? It's like a relay race. In sports, you know how the relay is played. One person starts with a batter, keeps on exchanging it, and finally somebody wins with the last one. So the baton is first placed in the hands of the court. So the court first gets in. This is after the agreement, etc., which I'm sure all of you know. So first the baton is in the hands of the court. What does the court do? There the court starts with granting some interim protection which may be required before the arbitration proceedings starts. Some interim injunction, interim attachment, etc., which is section 9. And sometimes the court must also appoint arbitrators under section 11 of the Act. So the baton is in the hands of the court at that stage. Then the baton is passed on to the arbitral tribunal. Once the arbitral tribunal is constituted, it can be a sole arbitrator, it can be a multi-member tribunal. So the baton is passed on to the arbitral tribunal. And now because of the recent amendments, the arbitral tribunal is now today capable of dealing with interim measures because of section 17 of the Act. So whatever powers are there for the court under 9 is now guaranteed to the arbitral tribunal also under section 17. So to that extent, the powers of the arbitral tribunal to a great extent that is available under 9 is given to the tribunal, and that gives a big advantage for a court also. Because many times courts used to spend days together sitting and deciding a section 9 petition. And it will not stop with one judge. It will go on and on and on up to the Supreme Court. And by the time the arbitral tribunal is constituted for the purpose of deciding the dispute, it would have consumed 5 years. So this 17 is a very, very important milestone according to me, because if there is already an interim order passed by the court, then what the court does is, with the consent of both sides, it appoints an arbitrator or an arbitral tribunal, and it says, I will extend this interim order till the arbitral tribunal takes it into takes the cognizance, and then you agitated the same interim measure before the arbitral tribunal under section 17. So to a great extent it saves time that way. Or the court has not granted an interim protection, even then the court gives that liberty of placing that before the arbitral tribunal so that the tribunal will decide it under 17. So according to me, this section 17 is a very, very important measure that was brought in after the amendment, in the absence of which courts were dealing with interim measures, and that used to take away a lot of time of the court, the crucial time of the court, where the court was not able to deal with the 34 petitions challenging the main awards. So that's a very, very important milestone. So the baton, to continue where I left, the baton goes into the hands of the arbitral tribunal. Then the arbitral tribunal proceeds further. It's possible that on and off an application may come before the court when the arbitral proceedings are pending, but there is no exchange of baton there. It comes by way of extension of mandate of an arbitrator, since the provision expects that it should be completed within a particular period. Or it can be a case where a substitution of an arbitrator is required due to any reasons. Or it may be a case where you will have to terminate the mandate of an arbitral tribunal. So these things may come before the court even during the pendency of the arbitral proceedings before the arbitral tribunal. So ultimately, till the award is passed, the baton continues in the hands of the arbitral tribunal. After the award is passed, the baton is again given back to the court in terms of challenging the award under section 34 or putting the award to execution under section 36 or challenging an order passed under section 34 under section 37 before a division bench. So the baton is given back to the court for the purpose of all these things. So this is a relay race. The relay race, if you keep it in your mind, you will understand how the arbitration process normally functions in this country. Right? Now, according to me, there are some suggestions which I would want to give to make it more effective and dynamic. One is, the most crucial part according to me is at the time when an agreement is drafted. Unfortunately, my friends, we are afflicted with a disease called as cut and paste, copy and paste. We have lost this ability of thinking originally, and it plagues the legal system in terms of advocates not being able to come up with good pleadings. They are not able to write good pleadings at all. They cut it from here and there and come up with one bunch of facts, and they leave all the essential facts. For instance, recently there was an application before me under Section 9. Section 9, as I was telling you, is for an interim protection. You have to bear with me for half an hour. So therefore the delay cannot be put on me. Please go against Indigo. So having come on the way from Chennai, I cannot just stop in 10 minutes and leave that. You have to bear with me whether you like it or not. So the interim protection that was sought for under Section 9, it must say somewhere that there is a manifest intention on the part of the party to arbitrate a case. Because many a times the intention is to somehow get an interim order, knock off, and then don't go into the actual process of arbitration. So the petition at the minimum must contain a fact to establish that there was a manifest intention on the part of the party who approached this court under 9 to arbitrate the matter. There is not a line. And that Section 9 application affidavit went on for 25 pages. 25 pages the boy has drafted. And I asked him one simple question. Forget these 25 pages. Please tell me, give me one line where you have said, where is your manifest intention to arbitrate? He said, typeset of papers, my lord. I said, I will throw the typeset of papers outside the court. You please tell me from your pleadings, where is the manifest intention to arbitrate? No, dismissed. So, a client believed him. A client handed over his case. A company handed over a case, whatever, with the basic notion that this man knows some law and that he knows how to approach a court and get them a relief, safeguard their rights, and he deprived them of that. As a result, just because it did not contain that one line or a small para where the party is expected to manifestly tell the court that he is going to arbitrate is absent, the entire case went into the dustbin. So this is something which plagues the legal system, and same happens in agreements. So what happens is that many a case I find that these agreements are prepared by this copy-paste, cut-copy-paste methods, where you have access to a lot of draft agreements. You just cut from here, copy from here, do this and that, and ultimately you will find that the agreement runs to pages after pages after pages, but it actually does not have a proper understanding or the peculiarity as between the parties who are involved in that agreement. So the most important thing according to me is there should be proper application of mind while drafting agreements. There is no use in having a 50-page agreement. The more clauses you have in an agreement, you can be rest assured that a lawyer will be benefited. There is going to be some problem in that agreement. The lesser it is better. The same I would say for judgments also. We find judgments running to 1,000 pages, 1,200 pages. I don't know whether the author of the judgment will remember what he wrote in the judgment. So, this unwanted, unnecessary elaboration, which is sometimes done to impress a client and charge extra fees, is actually counterproductive to the client. So, focus on agreement. Sit and draft every clause in that agreement and see what is required for that agreement. So clarity. clarity is of essence. Cut down this attitude of copy, cut, paste. Right? That's number one. Then, always try to include one clause which must talk about a negotiation or a mediation as a prerequisite prior to the commencement of arbitration. Sometimes this multiple mechanisms works because many times when it comes to court also, for instance, since I am sitting in that portfolio, I will find that one case where he also came. After hearing them, of course they irritated me for half a day. But apart from that, I found ultimately after such irritation, I had my lunch and then there's energy built up, right? So I found that why are these guys fighting? It's something which can be easily mediated or arbitrated. So I referred it to a very senior arbitrator on that. So even courts, when these disputes comes before courts, we do refer cases for mediation, for settlement of dispute, because we know that there is only a small area of disagreement which can easily be resolved. So if courts are going to adopt something like that, why is it that you should not have a clause like that in your agreement itself which contemplates to go for a mediation before the dispute enters into an aggravated form of arbitration? You will find that nowadays the statutes come up with such prerequisites. For instance, the Commercial Courts Act has specific provision which mandates that you have to go for mediation and come, unless you require some urgent interim orders, etc. So the intent is that try to mediate it, try to finish it off in a peaceful manner before you get into that aggravated fight before the tribunal or court or whatever, right? So this is the second thing which I would want to insist upon. Then, continuing from this cut, copy, paste, what happens? An arbitration clause in an agreement must contain the essential elements of arbitration. That's very important. I find some arbitration where I find clauses like parties may resort to arbitration. The man who had drafted this agreement had played a role. He had copied it from somewhere and it says that parties may resort to arbitration. One. There is another pattern which I find. Those agreements I find that it will say parties will resolve the dispute through arbitration. The court at Coimbatore will have the exclusive jurisdiction to resolve the dispute. It's mind-boggling. If parties are intending to arbitrate, why would courts in Coimbatore should have the exclusive jurisdiction? So, both cannot go together. Both cannot go together. One actually excludes the other, right? Why are you choosing arbitration? You want to avoid court. You know the problem in courts. But if you have both, so how do you enforce it? So these are small things which you'll have to focus on, and you'll have to ensure that the agreement must specifically contain the essential elements of an arbitration, and it should not have ambiguity, and it must sound mandatory. Without this requirement, howsoever big dispute you have, howsoever big organization you are, everything will go to dustbin. Everything will be a waste of time. So, from the beginning you would have noticed one thing, common thread, that is what I am attempting is, please focus on fundamentals. Please focus on these minimum things which you cannot get over at a later point of time. It's like asking the senior most advocate to argue in the Supreme Court with a pleading which does not support the case. So howsoever intelligent that senior counsel is, howsoever experienced he is, howsoever legal acumen he possesses, he can never help before the court because you have not fulfilled the fundamental thing that is required. Same applies to arbitration. Focus on agreements. That's the most important thing. One other thing which I find is, in places like Coimbatore, I find that the companies enter into agreements with overseas entities, right? When they enter into agreements, they just sign it. And ultimately they find that if they have to arbitrate, they have to go to some foreign country. So what do the advocates in Coimbatore and in other cases, what do they do? Immediately they rush to district courts and seek for anti-injunction or anti-arbitration proceeding. Now this has become a habit. This has again become a habit, right? You signed it. There is a clause available there. Now you cannot today say that I didn't know, it will have adverse impact, this and that, and then you attempt to go before the High Court or the District Court seeking for anti-arbitration injunctions. And now today the law is quite settled. Very rarely the courts will interfere. High Courts and Supreme Courts are frowning at this attitude on the part of parties trying to avoid something which they agreed with the overseas entity and then trying to injunct proceedings which commences in a foreign, in a seat in a foreign country. Keep this in mind. This is very, very important. So, a properly drafted arbitration agreement with a person who has thought through the entire agreement carefully will help you to avoid situations like this. Even though there are vibrant industries in Coimbatore, Karur, Thoothukudi, etc., the concept of arbitration still appears to be unfamiliar. There seems to be a reluctance to really move away from the traditional litigation, and there is a mindset problem. It requires change. That mindset problem requires change is something which can really be changed by organizations like this, and it has to be inculcated in the minds of people who are involved, whether large scale, small scale, that it's better to have an arbitration clause, it's better to negotiate and finish off, mediate, or ultimately if it does not succeed, go to the arbitration rather than going to the civil court, because it's impossible to find a solution in civil courts today. We can keep on saying there are some 50 million cases pending, 20 million cases pending, we can keep on saying that. Solution, I don't know. I really don't know. So that's not a topic which we are discussing today, but what I am attempting to say is that now that we know that the existing system is not going to really help in resolving disputes, commercial disputes, it's better that the players within that are inculcated with this sense that arbitration is the only solution available. That's very important. Then the next thing is, the arbitration agreement will be better if the arbitration agreement also says as to who will arbitrate, in the sense that it says that appointment will be made by an institution. That's what you are all attempting to do, the institutional arbitration. So once that happens, parties sometimes need not even come to the court under Section 11 for the purpose of appointment of arbitrator. So this is something which can be agreed upon between the parties by entering into an agreement. So when you are drafting the agreement, you must keep all these things in your mind. And you must see to that you don't get to the court unnecessarily unless it is warranted. Try to do everything away from the court, because your intention is to resolve your dispute away from the court. So why are you unnecessarily coming to the court? Better to have it outside the court. Right? Then, the advantage of an institutional arbitration is that they do have a panel of arbitrators who are enrolled by the institution. So, the presumption is that quality in the conduct of the proceedings is ensured. And it also ensures transparency and predictability of the cost involved. If an institution does not empanel proper arbitrators, it reflects on the institution. That's what the institutions must have in mind. So therefore, if the institution is striving to come in and help in the process of arbitration with its own set of arbitrators, the institution must be very careful while enrolling arbitrators into its panel. Whoever, maybe the domain expert, maybe the retired judges, maybe the senior advocates, etc., etc. Keep in mind that it ultimately will reflect on the name of the institution, like how a misconduct of a judge in a court will not just go with that name, it will reflect on the very institution itself. Same happens where you have one incorrigible arbitrator in your panel who can spoil the name of the institution itself. So that is something which institutions must have in their mind. When you get into supplementary agreements, multiple supplementary agreements, or when you enter into a fresh agreement whereby the party is considering the change of circumstances, get into a new agreement, and as a result the earlier agreement is wiped off, always keep in mind that either you specifically put an arbitration clause in that, or at least specifically say that the earlier arbitration clause in that will also apply in this agreement. If you don't do it, the dispute will not go to the arbitral tribunal. Even though the parties may be imagining that it will go before the arbitral tribunal. This is another important thing. And the time. Now, because of the introduction of section 29 capital A, time limits have been fixed. 12 months is what is intended. But what I find is that it is followed more in breach. People just come and file applications seeking for 6 months time, 8 months time, 12 months time. I ask them what is the stage of the arbitration. They say final hearing. Final hearing, why would the arbitrator take 6 months to pass an award? And you are expecting me to pass orders on a daily basis, dealing 100 cases very quickly. And the arbitrator having just one dispute before him, he will take 6 months to pass on. No, he has other arbitral matters. So this attitude of trying to prolong is a gene which is within us. Unless and the gene of our mindset is such that we are yet to understand the importance of these timelines. That is the basis on which you are getting into an alternate dispute resolution. And if the time does not bind you, for some reason Indians are not bound by time. Right? We don't care about time. The time factor, even though the legislation has brought in 29A, very casually, 12 months extension. The 29A says maximum 12 months. Extension sought for is 12 months. 6 months, 8 months. And you will find that arbitral proceedings are going on for 5 years, 6 years. You could have as well come to the municipal court, district court. Why did you waste your time in the tribunal? So, I am very, very, very particular on these timings. Even today I was so irritated in the airport, I did not allow anybody to come near me. Because I sit in court 2 minutes before the bell. It's like Vyadi Mariana. I am very, very particular about all that, because in my mind there are litigants who are waiting for their cases to be heard. And if I go late, what type of an impression am I giving? Same happened here. When I came here, I was late. Time. Because I have taken your time. I have taken your half an hour time. I don't have the right to do that. I may be holding some big position. That does not mean I can take your time. I can take your time for granted. Timelines are very, very important in arbitration proceedings. I will tell you this. In international arbitrations, I do not know how many of you have the exposure. In international arbitration, lot of time is given for preparation. They sometimes even give you 1 year time for preparation. But once the time is fixed, howsoever complicated the dispute is, trial will be over in 2 weeks. They don't allow you to make oral arguments and all that. You will have to appreciate the evidence, you will have to place the written arguments, awards are passed.